Okay, it looks like we've got the people settled in now and ready to start the presentation. So I'm going to go ahead and begin. Uh, well, hello, good morning, everyone. As I said, my name is Zach Passomer. I'm an enforcement attorney. Today we're going to be talking about probably some things that are relevant to some New Year's resolutions that people have. Uh, Still following. I'm not necessarily still holding on to any of my resolutions right now, but hopefully some of you in the audience are. But today we're going to talk about physical fitness and credit counseling topics and how our department is involved in them. Okay, with that introduction out of the way, let's talk about the uh, the heart of today's presentation, things that you should know about physical fitness centers and credit counseling. We're going to start with the one that is probably on a lot of people's minds in January, and that is physical fitness. So our department licenses businesses that offer physical fitness services. But it's important to look at the definition of physical fitness services because if the business does not meet the definition of providing physical fitness services, then the Physical Fitness Services Act does not apply. However, if a business does meet the definition of providing these services, then the Physical Fitness Service Act that we administer does apply. So, what are the physical fitness services? They are facilities or services for the development of physical fitness through exercise or weight control. And this term includes several things, including things that you may not expect, such as health or exercise centers, clubs, studios, or classes, health spas, weight control centers, clinics, or studios, figure salons, and tanning centers. These are all physical fitness services under the Physical Fitness Services Act, as well as athletics or sport clubs. So, with that broad definition of physical fitness services, what are not physical fitness services? Well, under the law, rehabilitative therapy administered by a licensed physical therapist, as well as certain activities even that normally would fall under the category of physical fitness services, such as any of the state of South Carolina and any of its political subdivisions, as well as any physical fitness centers uh, run by not-for-profit corporations. They would not fall under the Physical Fitness Services Act. Common question consumers have are what about gymnastics, martial arts, and dance studios and things of that nature? In these cases, all would be considered to be physical fitness centers if they're advertising as physical fitness centers. Some common examples that you may see of a business advertising as physical fitness centers would be, for instance, a martial arts instructor advertising that martial arts is a great way to stay physically fit. Well, under the act, physical fitness here is being promoted in that statement. So that would be physical fitness services. Another typical example would be something along the lines of an advertisement stating that gymnastics will allow your child to develop strength, agility, and coordination. Also, under the act, these are all byproducts of physical fitness, so physical fitness would be considered to be promoted here. And such a business using that advertising would be considered a physical fitness center. Why is this distinction important? It's because physical fitness centers must be licensed by the South Carolina Department of Consumer Affairs. So when choosing a physical fitness center, you want to make sure that you choose one that is licensed by our department. The reason why this is important is because a licensed physical fitness center means that if they are required to do so, the center has a contract that complies with South Carolina law and the Physical Fitness Services Act. It also means that the licensed physical fitness services provider maintains an appropriate surety bond. The way that you can tell whether or not a physical fitness center is licensed, apart from checking on our website, is you can go to the business and you can look for their license, which must be conspicuously posted at every location where monies or contracts are received by the center. So typically, what types of membership options do physical fitness centers offer? The ones that are most common are the month-to-month contract, where you pay monthly for the months that you want to use the facilities. Another type of membership are prepaid contracts. That is where a person pays in advance for the right to use the facilities. An example of this would be you paying $500 upfront for a 12-month contract. In this case, the membership is prepaid because the center has not yet earned the money because the provision of the monthly services after the first month has not yet happened. And then probably the most common outside of month to month, the most common type of membership would be the credit membership. This is where a debt is payable in installments or a credit service charge is made. On this next slide, let's go over what these two terms mean. What is payable in installments? Under the Physical Fitness Services Act, payable in installments means 4 or more periodic payments, not counting a down payment, in which a credit service charge is not imposed. An example of this would be a person signing a 12-month contract and the amount due is $600. The center permits you to pay 12 $50 payments. This would be considered a debt that is payable in installments. Now, there are some other instances in which a debt could be payable installments, but they're rare, especially in the context of gym memberships. So we won't be going over them in this presentation. Now, looking at this definition, you may be asking what a credit service charge is. A credit service charge is an extra charge that you must pay as a result of paying over time instead of purchasing with cash. You can think of it similar to interest. So, for example, let's go back to that same 12-month contract. You may be given the option to pay in full, a $500 cash price for that contract, or the physical fitness center may give you the option to make 12 $50 payments. This would be what's known as the credit price. The extra $100 in difference between the two prices is known as the credit service charge, or more formally under the Act, it's known as the time price differential. Now, whenever you have credit contracts, certain disclosures must be made to you. The Federal Truth in Lending Act requires that certain disclosures be made to you when making credit transactions. These disclosures are often in the form of easy to read boxes known as TILA or TILA boxes. The purpose of these boxes is to allow you to see the overall cost of credit. I believe most people, if they have financed a vehicle, they are familiar with with these TILA disclosures. If there is a time price differential in the gym contract, state law requires another disclosure in addition to the TILA disclosures, and it must be separate from the TILA disclosure. And that is the time price differential disclosure, which you can see here on this screen. It must disclose in detail certain things such as the cash price, including taxes, less the total down payment, the unpaid balance, and the finance charge, and the time balance, and the time sale price. Prepaid and credit contracts must be in writing if the term is more than 3 months in duration or the total cost is more than $200 in amount, or if the contract is for a personal trainer, $300 in amount. The contract must reveal the finance charge, if any, that you agree to pay. The contract also must clearly state the street address or the location of the center or the outlets that you may use if there are multiple outlets that are available for your use in your contract, the major facilities and services that the center offers, and which services are not subject to a refund. And as stated earlier, the contracts must also have the appropriate TILA disclosures, and they must contain a right to cancel, which I will discuss a little more in detail coming up. So under the Act, there are several contractual provision or prohibitions. Under the law, a contract cannot allow late fees to be imposed before you are more than 10 days late. They also cannot allow for late fees to exceed the lesser of 5% of the unpaid installment or $25.50. It's important to note that the dollar amount here, the $25.50, that is a variable rate that increases in 2-year increments, but that is the current late fee. It went into effect, I think, in mid 2024. So it may increase in a couple years, but right now it's 25.50. Another contractual prohibition is that a contract may not seek attorney's fees from you that exceed 15% of the unpaid installment. They cannot waive the required provisions of the Physical Fitness Services Act. Physical fitness service contracts cannot be for a term longer than 24 months and cannot have a length measured by your life, the life of the center, or any similar indefinite term. It's important to remember that any contractual provision that does not comply with the Physical Fitness Services Act is unenforceable against you. Now let's go back to the right to cancel. Credit and prepaid contracts must contain a right to cancel within certain requirements. So the first one is that there must be a right to cancel within 3 business days after signing the contract. Other statutory ones are that there is a right to cancel uh, on the event of your death, a substantial physical disability certified by a physician, which makes it permanently impossible for you to use the services, or your permanent relocation to a residence over 50 miles distance from an outlet operated by the center, if the center is unable to arrange for you to use another center with equivalent major facilities and services. Now, your death might seem like a strange reason for cancellation, but what it essentially means is that the contract cannot be enforced against your estate. Also, other than the cancellation within the 3 business days, the physical fitness center might require proof if any of the events triggering cancellation rights occur. So it is permissible under state law, for instance, for a physical fitness center to request a death certificate to cancel the contract, or some sort of proof of your disability, or some sort of proof that you've moved over 50 miles from an outlet. There are certain optional contractual provisions that are allowed under state law. Credit and prepaid contracts may have more liberal rights of cancellation than outlined in the statute. For example, as I just described, state law requires the ability to cancel a contract when you relocate more than 50 miles from an outlet. Um, as far as having more liberal cancellation rights, a gym could bring that restriction down and say that if you move 25 miles from the nearest outlet, they'll allow cancellation. So businesses are allowed to provide more liberal cancellation rights than state law requires. Another thing that they are allowed to include in their contracts are provisions to provide for an extension of the term of the agreement for a period equal to a period of temporary disability or pregnancy, or for any justifiable or reasonable cause. That's what's known as kind of that's known as a membership freeze on a lot of contracts. Other optional contractual provisions that are allowed is that the contract can specify that the written contract constitutes the entire agreement between the parties. And contracts can have a renewal option. So when it comes to renewal options, there is a standard renewal option, which can be longer than 1 month, but not longer than 1 year. It would be exercised by you in writing or by payment of part or all of the renewal price. And it's exercised near the expiration of the original contract term. Another possibly more common type of renewal that we're seeing nowadays is the automatic renewal option. For this to be effective, you must opt in to automatic renewal by initialing the provision on your contract. It must be disclosed in bold 14-point font on the front page of your contract. And at that point, the contract becomes month to month. Or the price may not increase or decrease without written notice within 30 to 60 days before the change in price. And they must notify you of automatic renewal near expiration of the original contract. So it's important to make sure that you update your address with the center if you move in the middle of your contract term. Let's talk about the issue of electronic contracts. Many gyms these days are now using electronic contracts where the contracts are made on tablets and copies are emailed to consumers. Electronically signed contracts are just as valid as contracts signed with a pen. Check your email for the copy of the electronically signed contract if you did sign one. Now, under federal law, centers cannot make electronic fund transfers, including ACH, a condition of extending credit. It can be an option for payment as a convenience to you. It just can't be required as a condition of the extension of credit. Some centers might charge you a processing fee for using your credit card to make a payment. This practice is legal. However, if centers are going to charge such a processing fee for using a credit card as a payment method on a credit contract, that charge must be included in the calculation of the finance charge that we've discussed, and it must be properly disclosed to you. So that covers the Physical Fitness Act, but there are some general tips that we want to put out there for you before you sign up for any kind of gym membership. First, of course, you want to talk to a doctor before beginning any workout plan. Listen to your gym staff to perform exercises correctly so you don't hurt yourself. One thing you should be wary of is to be leery of promises of rapid results with little effort. Took time putting that weight on, so it's going to take time to take it off. Not all gyms are the same. It's best practice to shop around and see what features are offered and what works best for you. And with any situation involving a membership, carefully read your agreement before signing it. So that pretty much covers the Physical Fitness Services Act. So now we're going to change gears to our next New Year's resolution to be more financially sound, and we're going to discuss credit counseling. So the first topic for credit counseling is what exactly is included in a credit report. Type of information on a credit report includes personal information such as your name, birth date, phone numbers, any addresses that you've had attached to you, and your social security number. It's also going to include a list of accounts, current and past accounts, the credit limit on those accounts, any account balances that you may have on them. It's going to include your payment history, the creditor's name on the accounts, and the date that the account lines were open and closed. Also included in a credit report is any number of public records, including liens, civil suits and judgments, and bankruptcies. Also, things that affect a person's credit report include credit inquiries. Credit inquiries are divided into two types: hard inquiries and soft credit inquiries. The distinction between these two is that a hard credit inquiry is when you have applied for new lines of credit. That is the credit check that is made when you have filled out a credit application. Those show up and they can affect your credit score, which I'll go into more detail uh, in a few slides. But a soft credit score is when you or your creditor check your score, or also a potential creditor checks your score or checks your credit report. So that can include things such as a potential creditor checking your credit report to evaluate your fitness for a pre-approval, things of that nature. After you attain your credit report, it's important to review it and carefully check it for inaccuracies. What you want to do at this stage is to evaluate whether the debts on the report are yours. If they are not yours, you have the right to dispute the debts. When you dispute a debt, a consumer reporting agency typically has 30 days to reinvestigate the accuracy of the debt on your report. Inaccurate debts or debts that cannot be verified must be removed. The debts that can be reinserted upon certification from the furnisher that the debts are accurate. If the debts are yours, you need to evaluate a course of action to address these debts. Now let's talk a little bit about credit score. A credit score is a three-digit number designed to predict if you will pay your bills on time. The higher your score, typically the better the credit terms that you receive will be. Generally speaking, credit scores are in these following ranges. So the ranges that most people are familiar with are the FICO scores, and they typically follow these ranges. And they go from 300 to 579 as poor credit and gradually go up to 740 to 799 as very good credit, or 800 to 850 would be considered excellent credit. There are many things that affect a credit score, including whether you pay your bills on time, how many recent applications you have. The more new accounts you have, the more potential creditors think that you cannot pay your bills or stick to a budget. So be careful of having too many store credit card offers, or agreeing to too many credit card offers. Weigh the benefits of the discounts received for signing up for a store credit card versus the impact on your credit score. Another thing that is evaluated in your credit score is your mix of credit. Typically, what you're looking for as far as a healthy mix of credit would be a mix of long-term loans, some short-term loans, and revolving credit accounts that are all timely paid. What this would do would show a potential creditor that you are at a lower credit risk. Another thing that affects a credit score is what's known as a credit utilization ratio. This is the amount of credit that you use divided by your total available credit. Ideally, you want to keep this ratio below 30%. So obtaining credit reports nowadays is a fairly straightforward process. There are services that you can pay to receive them, but you also have a right to receive free credit reports through annualcreditreport.com. This is the way that's authorized by federal law. You can visit their website or call the phone number on the screen. You can request free copies of your credit reports every week. That may be a little overkill as far as reviewing your credit report. We recommend you review your credit report at least once a year. It is worth noting that this free credit report does not contain any of your credit scores, though there are some services that provide credit reports and credit scores. Now, if you have checked your credit report and have evaluated or need help evaluating the debts that you need to attack and feel that you may need the services of a credit counseling service, we will now discuss the different types of credit counseling services that are out there. First one is what's known as a debt management plan. This is where uh, you pay the credit counseling service, who then distributes this payment among your creditors. Another type of credit counseling services is credit repair. And what these credit counseling services do is that they offer to improve your credit record, your history, or rating, usually by disputing items that are on your credit report. Another type of credit counseling services includes debt negotiation and settlement, and this is a third party that actually assists you by negotiating with your creditors to reduce or defer your debts. It's important to note that not all credit counseling organizations offer all these types of services, so it's important to do your research and choose one that offers the services to meet your specific needs. So there, as I've said before, credit counseling services or companies that offer them must be licensed by our department. And there are a number of requirements in order to maintain licensing. So as far as some of the first requirements go, a business must provide you with a credit education program designed to improve your financial literacy. They must also provide you with a thorough and written budget analysis, and they must determine whether or not that the services that they offer are suitable for you. You must reasonably be able to meet the requirements of their budget analysis. There are also maximum amounts under the Credit Counseling Act that you can be charged, and a written contract must be provided to you and it must meet statutory requirements. Now, some of these requirements are that funds paid by you for the payment of your creditors in uh, a, 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 a debt a debt plan. Funds paid for your creditors must be placed in a trust account. They must be distributed within 5 days of receiving them, and you must be given signed, dated receipts or access to the receipts upon request. Your funds must always be kept separate from the business funds. They cannot be commingled with the business's funds. The business must also provide you with an accounting at least once every 3 months or within 7 days of written demand, but no more than 3 times within a 6-month period. Now, the fees that these businesses are allowed to charge for these services are set by our regulations, and they vary by the types of services that are offered. So as you can see here on this slide, if they're administering a debt management plan, they can charge you $60 for an initial consultation fee, a $50 charge for a plan setup fee, and a monthly maintenance fee of $10 per creditor, though that cannot exceed $70 overall. There's also a reinstatement fee that's allowed at $25 if you leave the plan and then want to reinstate it. And upon approval from our department, there is a $10 per month additional fee for related services, or what's known as a service fee. Now, when it comes to credit repair services, the allowable fees are an initial consultation fee of $60 and a monthly maintenance fee of $50. And again, the reinstatement fee is $25 should that situation arise. Now, as far as debt settlement services, similar to the other two, there is an initial consultation fee of $60 that is allowed. And like the debt management plans, the monthly maintenance fee is $10 per creditor, though not to exceed $70 a month. So it is very important to choose a licensed credit counselor for many reasons, because licensed credit counselors, like physical fitness service providers, must maintain a surety bond. But unlike the physical fitness services providers, they must also pass a criminal background check and they must provide their own financial information. They must also complete 12 hours of continuing education every 2 years, and they must abide by other applicable laws for credit counseling. Now, like with gym contracts, there is a right to cancel in credit counseling service contracts. This disclosure must be stated in the contract near the signature line, and it must state that the contract or the debt management plan can be canceled at any time and for any reason. If you elect to do so, you must give the credit counselor 10 days notice. And once the services are canceled, you are entitled to a refund of all unexpended funds that you have paid. Now, when it comes to debt reduction and also determining whether or not you need the services of a credit of a credit counselor, uh, one of the things that they may discuss with you or educate you on are different types of debt reduction strategies. But whether or not you are getting professional assistance, it is important to develop a plan to get your debts under control and to pay off your creditors over time. So one popular way that this can be done is what's known as a debt avalanche, where you would pay the minimum on all debts with excess payments going to the debt with the highest interest rate. And then when that debt with the highest interest rate is paid off, extra payments would then go to the debt with the next highest interest rate until all debts are paid off. So you keep working your way down. That's what's known as the debt avalanche. Another common approach for debt reduction is what's known as a debt snowball. This would be where you pay the minimum on all debts with extra payments going to the debt with the smallest balance. And then when that smallest debt is paid off, you move up to the next smallest debt. So you work, rather than working your way down, you work your way up. But these are two of the most commonly known debt reduction strategies that are out there. It's also important when you're looking in this space for credit counseling services to be wary of credit counseling scams because they are out there. It is important to be on the lookout for companies that offer certain things, such as insisting that you pay before they help you. That's not allowed by law. If they are telling you not to contact the credit reporting agencies directly, that is another red flag of a scam. Especially if they tell you to dispute information that you know is accurate. If they're telling you to dispute debts on your credit report that you know are legitimate, that that is a sign of a red flag, or that is a sign of a scam because that's not allowed by law. As I've said before, a credit counselor can only, well, and you as well, you can only dispute legitimately inaccurate debts. Another red flag is if they tell you to lie on any applications for a credit or a loan, and if they don't explain your legal rights when they tell you what they can do for you. One that we have seen out there, a common scam, is that they may promise to create what's called a new credit identity. A scammer may ask you to use what's known as a CPN or a credit privacy number, which is a 9-digit number that's formatted like a social security number. It could also be called something like a credit profile number or a credit protection number. And there are companies out there that sell CPNs and market them as replacement social security numbers, promoting the idea that these CPNs are legitimate. For example, one site advertising CPNs claims the numbers are fully tri-merged with the Social Security Administration. In reality, these companies are scam artists. They may obtain Social Security numbers by dubious means. They may also ask you to apply for an employer identification number from the IRS. That's not a social security number for, or that's not a substitute for your social security number. And kind of going with what I said previously about disputing accurate information on your credit report, if they promise to hide your negative credit history or bankruptcies on your credit report, that's an obvious red flag because that's not something that legitimate credit counseling companies can do. So now that we've kind of talked about those two fields of licensing and things that our department is involved in, let's talk a little bit about unfair trade practices. Violations of either the Physical Fitness Services Act or the Consumer Credit Counseling Act are automatic unfair trade practices. And under state law, the remedy for violations of this act is triple damages and attorney's fees. So if you believe that you have encountered a company that is violating either one of these acts, you would need to speak to a private attorney for any action for unfair trade practices. Now, that kind of brings us to the end of our presentation here, but I do want to particularly highlight our YouTube page, SCDCA TV, because we have a multitude of videos, including presentations like this one that we have stored on that page. I've highlighted this one specifically. It's a playlist to learn about credit. So it includes presentations on all sorts of credit related issues, such as credit myths, credit reporting, debt collection basics, things of that nature. So I definitely wanted to highlight that because I figured if you're here today learning about uh, our licensees and things related to credit, you may have some questions regarding these other topics as well. So that's the end of the presentation today. So at this time, I'd like to open it up for questions if anybody has any. So I'll give you a few minutes now to type it into the question box if you do have any. Looks like we have a couple already. Uh, First one, are your slides available for downloading? If they're not already in the handouts section uh, of the uh, of the controls for GoToMeeting, I believe we can probably send out these slides to attendees. I can get with public information about that. The next question we have is Planet Fitness adds a once a year management fee. Where is this disclosed? That would be disclosed on, it should be disclosed in your contract. So I would recommend that you review that agreement carefully. Okay, doesn't look like I'm seeing any more questions, but if you do have a question, you can still type it in and I'll try and catch it. While we're doing that, I will invite you to connect with us on social media. We maintain Facebook page, Twitter page, and I've already mentioned our YouTube channel. But if you'd like to connect with us, learn more about consumer-related issues, I encourage you to check those out. Also, we have publications on all sorts of consumer-related issues that can be sent to you free of charge. We have hard copies that we can mail out, but I'll also note that I believe they are all as well on our website. Oh, as it says, all of our publications are available on our website. So you can also visit our website, consumer.sc.gov, and find many publications on consumer issues. And we do have some upcoming webinars. This is our usual Wednesday webinar. So we have one each week. The next two that we have on the schedule include the 2025 Homeowners Association Complaint Report. And on February 12th, we will have a webinar on common romance scams. Uh, both of these will start at 10:30. Okay, I'm not seeing any more questions, so we're done here for the day, and I thank you for spending time with me, and I hope you gather some useful information from this webinar, and we'll see you at the next one.